Ladies and gentlemen, the session 1 begins very soon. Please take your seats. Thank you.
Now, we begin session 1. We cover highly important topic in patent law here, claim construction. This session deals with the most difficult and challenging questions in the history of our conference. That cause the most pain with the panelists, but that makes this moment all more exciting. Let's see how the panel tackles the problem. The moderator is the Honorable Chief Presiding Judge Kyung Kim of Patent Court of Korea. Please join me in welcoming her.
Good morning, everyone. I'm Chief Presiding Judge Kyung Kim from the Patent Court of Korea. It's my honor to serve as a moderator of the first session. First, I'd like to introduce our distinguished panels of this session. I will present one by one from my side. The very next to me is Judge William ALSUP from the US. After graduating from Harvard Law School, Judge ALSUP began his career as a law clerk to Justice Douglas in 1971. Before he was appointed to a district judge of the Northern District of California in 1999, he was worked as a lawyer and special trial counsel. He is also an author of several books. Next is Dr. Thierry from Switzerland. Please welcome him. Dr. CALAME has a background both in science and law. Dr. CALAME studied natural science at the Swiss Federal Institute of Technology and then studied law at the University of St. Gallen. He has vast experience of IP-related litigation and published many books about patent, copyrights, and trademarks of Europe and Switzerland. He is a member of many IP-related international associations, such as the International Association for the Protection of Intellectual Property, the International Trademark Association, and the European Patent Lawyers Association. Then, lawyer Inji Fang from China. Lawyer Fang received a Bachelor of Engineering from Yanbian University in China in 2011 and a Master of Intellectual Property from KAIST in 2016. From 2011 to 2013, Ms. Fang worked at the Nanjing Jingwei Patent and Trademark Agency in China, and since 2018, Ms. Fang has been working at LIFANG and Partners Law Firm in China. Ms. Fang is working for the same law firm as Mr. Linghu and co-authored the answers to this session. In today's session 1, Ms. Fang is with us as panel on behalf of Ms. Han. Then, Judge TaekSoo from the Patent Court of Korea. Judge Jung first took the bench in 2001. During his career as a judge, his main area of expertise has been IP rights. He had worked at the Patent Court of Korea from 2012 to 2014 and then came back here again last year. For 2 years while he was away from the Patent Court, he worked as a research judge for the IP cases at the Supreme Court of Korea. We have another Korean judge, Presiding Judge Taeil from Seoul Central District Court. Since Judge Park was appointed as a judge in 2002, most of his working field has been IP invalidation and infringement litigation. He earned a doctor's degree in IP and published books and papers. Next is Judge Oliver Shen from Germany. Judge Shen first took the bench at the District Court of Munich in 2007 after serving as a public prosecutor for 4 years and achieving his doctor's degree in 2004. He has studied at Waseda University in Japan from 1997 to 1998 and visited the Japanese Supreme Court through exchange program in 2009. Judge SCHÖN is now a judge at the District Court of Munich and also a scientific research assistant at the Federal Supreme Court. Last but least, Judge Toshihiko TSURUOKA from Japan. Judge TSURUOKA was appointed as an assistant judge of Tokyo District Court in 1982. Since then, he has served several courts in Japan, and now he's a presiding judge of the International Property High Court in Tokyo. So let's start the first session. The topic of this session is claim construction for lawful protection of patent. As you know, even though claims are written in words, they are not understood in one way. Moreover, patentees tend to use claim terms to confuse us. So, defining the claims and determining the scope of right by claim construction are as important as making inventions itself. In this session, we want to know how each country makes general claim construction and determines the scope of right when claim language is not clear, and how they handle means plus function claims and product by process claims. Due to the time limitation, we have already exchanged questions and answers before this conference. The details are in the distributed prints, so please refer to the prints. Now PowerPoint 1. There is PowerPoint 1-1. The first topic is criteria and basis for claim construction. We asked the panelists this question. In cases where claims are stated in words, of which meaning can be identified by referring to a language dictionary or a technical terms dictionary, do courts determine technical compositions or technical scopes solely based on such statements, or should courts still refer to the descriptions or drawings of the inventions to construct the words stated in claims? In most countries, panels answered they still refer to the description and drawings for claim construction. In China, it is different by procedures, the administrative and the legal procedure. This question is for Judge TSURUOKA. I'm aware of the Japanese Supreme Court decision 1987 Kyung 3 on March 8, 1991. Could you explain what the court meant by special circumstances in the decision? It seems that the holding of this case does not apply in the infringement determination. Also, the scope of claims seems to depend on the claim language alone, even in the infringement determination phase. If the scope of claim is clear from the claim language, then what are the circumstances where the gist of the invention would be differently interpreted by the description of the invention when determining infringement issue compared to when determining inventive step? Can you provide us any specific examples?
Thank you for the question. The Supreme Court decision you mentioned holds that the determination of the gist of the invention when judging the inventive step should be made on the basis of description of the claim unless there are special circumstances. And this decision points out two cases as special circumstances. One is the case where the technical meaning of the claim cannot be clearly understood. And the other is the case where the description of the claim is apparently incorrect in light of the description of the specification. This Supreme Court decision does not apply to infringement decisions. However, even in the case of inventive step determination, if the technical meaning of claim is unclear, the description of the specification will be considered. On the other hand, in the case of infringement judgment, if the technical meaning of the claim is clear, the scope of the claim can be determined without considering the description of the specification. Therefore, my idea is that the interpretation of claims is not so different in both cases of inventive step judgment and infringement judgment. For example, let's consider the case where the term fixing member is used in the claim, but there is no explanation in the claim about its specific contents. In this case, it is not clear what kind of means is used in fixing. So we will consider the specification. And if there is only an example of screwing in the specification, fixing member will be interpreted as a member that is fixed by screws or similar means. Therefore, members that are fixed by magnetic force are not included. And I think that this is the same in the case of inventive step judgment and infringement judgment. Thank you.
Thank you for your kind answer. Then we are going to next PowerPoint. This PowerPoint is about this question. In cases where the general meaning of what is disclosed in claims is different from the specific meaning of the features as disclosed in the description and drawings of the invention corresponding to the elements of the claim, how specific should the meaning of the descriptions or drawings be for courts to construct claims based on their specific meaning? Let's listen to the answers to these questions from the panelists. The first question is for lawyer Fang from China. In your answer to this question, you said that technical features with equivocal literal meanings shall be interpreted based on the descriptions of the disclosures of the description and drawings, and that construction of technical features shall be consistent with the purpose of the invention and shall not be conflict with the common knowledge in the art. Then, when the ordinary meaning of the claim language is clear, is it ever allowed to interpret the claims as having the specific meaning under the description of the invention if the specific meaning is different from the ordinary meaning?
Oh, yes, thank you for your question. In this case, in China, if the wording of the claim is specifically defined by the description and the drawings, such definition shall be followed. Previously, we said that if the technical features with equivocal literal meanings shall be interpreted based on the disclosure of the description and the drawings, this case is the administrative infringement case. So in the case, if the technical features with equivocal literal meanings, the court should to interpret the meaning of the claims based on the description and the drawings. Thank you.
Thank you. And the second question is for Judge Jung from Korea. According to the legal principles set out by the Supreme Court of Korea, what level of disclosure is required in the description of the invention to lawfully interpret the claims as having a meaning different than the ordinary meaning of the claim language?
I am very pleased to be here to share opinions. It depends on the case. However, if the description of the invention shows consistent and specific meaning that corresponds to what is stated in the claim, reasonable interpretation would be in accordance with the specific meaning instead of the generally accepted meaning from a language dictionary or a technical terms dictionary. The Supreme Court of Korea has held that the meanings of the claim language should be interpreted objectively and reasonably, considering the description or drawings of inventions. Regarding the role of descriptions of the invention as dictionaries, the Supreme Court also held, in special circumstances such as when a claim term has a special meaning defined or explained in the descriptions or the drawings, the content of the invention must be determined from objective and reasonable interpretation of the term. For this, its technical meaning must be contemplated in reference to the descriptions and drawings, while taking into account of the general meaning of the term as the basis. You could say that the description of an invention has two dictionary functions: the function of a conceptual language dictionary and that of a synonym dictionary. First, the Supreme Court held that the term stated in the specification should be consistently constructed according to the generally accepted meaning, unless the term is defined in a specific meaning and used as such in the specification. Conversely, if the description of the invention provides a specific meaning of a claim term that is different from its general meaning, the technical meaning of the term should be consistently constructed according to the specific definition. You could say that this is the function of a conceptual language dictionary. Second, in the absence of a definition, let's say the descriptions show a specific feature through several embodiments and yield a consistent and specific meaning of the methods corresponding to the claim language, then the technical meaning of the statement in the claim should be consistently constructed according to the specific meaning. You could say that this is the function of a synonym dictionary. In this vein, the Supreme Court held that where the specifics of the technical features cannot be identified from the claim language, the courts should determine the technical features the claim language seeks to deliver by also looking at other statements and drawings in the specification to determine the scope of rights or protection. Thank you.
Thank you, Judge Jung. And next question is for Judge ALSUP from US. You introduced that there are 4 ways where the specification may define a claim term distinct from its ordinary meaning under the US law. One of the 4 ways relates to the function of the dictionary of a specification. What type or degree of description do you need to see from the specification to say that the specification functions as a dictionary and defines terms by implication? Do you have any cases or your own experiences to share in this regard?
Yes, the answer is it must be very clear under our U.S. law that the patentee defined a term in a way different from its ordinary and accepted meaning by those skilled in the art. So it must be very clear. It can't be ambiguous. It has to be very clear that the specification provided its own definition. You asked me for an example in my own experience, and I went back and looked at some of my orders, and I have one from a case called Oracle versus Google, and in that case there was this exact point came up, and I held in that case that the specification did define a term, and in that case the term was, quote, computer readable medium, close quote. The specification specifically put that term in quotation marks and then gave a definition. And I held in that case that the specification had in fact given a specific enough definition. And the quotation marks used around the phrase were important in helping me decide that based on the law that our federal circuit, our Court of Appeals in the U.S. Has used. So the short answer is, if you want to be your own lexicographer, if I'm saying that right, you have to be very clear that you are defining the term in the way you want it to be used. If it turns out just to be an argument between that paragraph and this paragraph, that's not good enough.
Thank you. And let's go to next PowerPoint. This PowerPoint is about this question. Do courts consider prosecution history as a basis for claim construction? I have a question to Judge Shen and Dr. CALAME. First, I have to ask Judge Shen. I believe that the German court generally do not look at prosecution history for claim construction, but it is said that if a party submits documents on prosecution history during litigation, the documents can be considered as a statement of a technically skilled person. Can you describe what a technically skilled person specifically means and whether the statement of a technically skilled person is used to construct the claims?
Thank you very much for this question. Is it?
Push that button
Okay.
on the...
Do you hear me? Okay. So thank you very much for this very interesting question. According to German law, Section 14 and Article 69 of the European Patent Convention, you cannot look at the prosecution history in order to understand the meaning of the claims. The reason might be that it should be possible for like a third party to understand the patent just by reading the patent as such. We did have, or we do have, a discussion in Germany. If you can look, for example, at the patent application in order to understand if there's a change between the patent application and the granted patent as such, because these are two documents that are published, but this is not decided yet. So in infringement proceedings, we sometimes do see the case that the plaintiff has an interpretation about claims which is in opposite of what he said during the application process. So according to the law, we cannot look at the application process documents. So, but we say, because the statements during the application process are made by technically skilled persons, we do consider them inside the case as a statement of a technically skilled person at the time of applying for the patent. And if one party wants to have a different understanding, they do have to explain in detail why they do change their opinion, or why do they have a different understanding than the statement during the application process. So it's a way of ensuring that the interpretation during the application process is similar to the one during the infringement process. Thank you.
Thank you, Judge Shen. And next question is for Dr. CALAME. The Pemetrex case involved in disputes on whether prosecution history can be considered for claim construction. In that case, was it ever disputed whether prosecution history may be used for claim construction, not just with infringement by equivalence? Also, how is the Federal Supreme Court's decision different from the Federal Patent Court's decision?
Yes, thank you very much for that question. Following on from the response from Judge SCHÖN, of course, Article 69 of the European Patent Convention equally applies in Switzerland. But nevertheless, it's kind of common practice in Switzerland that very often the prosecution history would also be used as a means of interpreting the claims, a means of interpretation. And in the Pemetrex case, actually, the Federal Patent Court said that, that indeed the prosecution history was relevant in construing the claims and also for the purpose of determining whether there is infringement under the doctrine of equivalence. This went on to the Supreme Court, and the question whether the prosecution history could be used as a means of interpretation was left open by the Supreme Court in the end, but then the Supreme Court overturned the decision of the Patent Court. And because you asked me whether there were differences between these two decisions, I can maybe just 1 minute, I can explain that difference. So the Pemetrexed case, for those of you who are not familiar with it, now that is a patent of Eli Lilly. It is about the use of Pemetrexed disodium for the manufacturing of a medicament for treating or inhibiting tumor growth, and that is also used in combination with vitamin B12 or a derivative. We really don't need to go into the complicated details, but what is important for the purpose of this discussion is that Eli Lilly, in the course of the prosecution history, had to narrow down the claim language to overcome an added matter objection of the patent office. And so they started out with an antifolate, so Pemetrexed disodium is an antifolate. They first narrowed down that to Pemetrexed, and then they further narrowed it down to the disodium salt of Pemetrexed. And then the generic on the market, the Octavius product, was basically a Pemetrexed diacid. And I'm kind of simplifying the facts now because there were other salts involved. But so the question really is, the patentee had to narrow down to the disodium salt, and the infringing product was the diacid. So the question was whether that would amount to to an infringement under the doctrine of equivalence. And that is where the patent court said that the prosecution history plays a role in interpreting the claims, and also they basically said that there wasn't any infringement on the basis of a principle of good faith because they specifically had to narrow down the scope of protection in the prosecution history, and so they could no longer rely on a extended scope of protection. And the Supreme Court turned that around and basically left open the question whether prosecution history could be used for construing the claims, but said that in any event, there was infringement on the doctrine of equivalence following on from the UK Supreme Court judgment and the German Supreme Court judgment. Thank you.
Thank you for your kind explanation. And let's go to the second topic. The second topic is claim construction and limitation or expansion of scope of protection. The PowerPoint is about this question. If technical compositions and scopes become more limited or narrower based on the descriptions and drawings of the inventions compared with those identified based solely on the literal language in the claims, which composition and scope do courts rely on between those disclosed in the claims and those in descriptions and drawings when deciding patentability and patent infringement, respectively? The answers were all claims in both the patentability step and patent infringement step. So this leads to the next PowerPoint. This is about this question. In cases where there exist valid grounds for invalidating a patent, for example, when certain matters that are literally included in the claims are not supported by the description of the inventions, do courts limit the claims themselves on account of such grounds for invalidation? And if they do they apply this approach for judging both patentability and infringement, or either of them? You can see the answers on the screen. Here is the question to Judge Jung. In Korea, the scope of protection of a patented invention can be limited when the issue is infringement, if certain requirements are met, unlike when deciding patentability. Please explain how this legal principle of Supreme Court limiting the scope of patented invention can be reconciled with the general principle on claim construction set out by the Supreme Court.
First of all, I'd like to say that this is a highly disputed area. The Supreme Court of Korea consistently applies the legal principle for claim construction for judging patent ability and patent infringement. It has held that, in principle, the scope of protection of a patented invention should be determined based on the claim language. And other descriptions in the specification may come in as supplements when the claim alone is insufficient to identify the technical feature or to determine its technical scope. Even in such cases, broad interpretation based on other statements in the specification is not allowed. Neither is narrow interpretation if the claims alone clearly identify the technical scope. This legal principle serves as the default standard. Meanwhile, the Supreme Court provided a supplemental principle in this regard that when literal interpretation of a claim is clearly unreasonable based on other descriptions in the specification, such as when part of what is literally included is not supported by the detailed description of the invention, the scope may be narrowly interpreted in consideration of the invention's technical idea, other descriptions in the specification, the intent of the applicant, and legal stability of others. The supplemental principle is also grounded upon the basic principle for claim construction. So it does not go against the general rule of claim construction. Rather, it provides a method of limiting or adjusting the scope of protection of an invention to provide reasonable and appropriate case-by-case infringement determination. Let me share where the supplemental principle in the infringement determination is coming from. For a claim that is overly broad compared to its actual technological contribution and that was not supported by the description, so it should have been rejected. It should not be given protection of the full scope of the claim at the infringement determination stage because it extends legal protection to the technical idea, neither acknowledged nor disclosed by the inventor at the time of filing. Then, the supplementary principle is also based on the understanding that the interests of the patentee and others are better served when protection is given to what is actually worth protecting and infringement is not found by the other's practice that does not intrude the portion. This makes more sense than invalidating or denying protection of the entire scope of the already registered patent due to some errors in the claim. Thank you.
Thank you. And I have another question to Judge TSURUOKA. Let's say a patent claim is a Marcus type claim, and the description of the invention either lacks support or enabling disclosure for some of the elements that may be selected among the Marcus group. If infringement of these elements is disputed in a lawsuit, would a Japanese court still hold that the elements are infringed? How would you balance the two values, fair protection of patent rights and protection of the general public's interests in this sense?
Thank you very much for interesting question. And the answer is yes. But in Japan, defendants can file a patent invalidation defense in infringement lawsuit. And in the case of the question, the defendant will argue that the plaintiff's patent is invalid due to violation of support requirements or enablement requirements. And the court will accept this defense and dismiss the plaintiff's request. A difficult problem arises if the defendant does not claim an invalid defense. However, I think it is inevitable that the plaintiff's request will be accepted as long as the defendant does not claim an invalid defense. That may be the result of self-responsibility. Thank you very much.
Thank you. And the next question is to Dr. CALAME. In a proceeding that deals with both of patent invalidity and infringement, what kind of action should a patentee take in order to limit the scope of claims to remove a ground for invalidity? Also, can a patentee ask the court to amend the scope of claims in an invalidity proceeding?
Yes, thank you. Yes, it's very important for the plaintiff, the patentee, to actually request the court to limit the claims. That's not something the court will do on its own. And basically what the patentee can do is can limit the claims by way of a main request or by way of auxiliary requests, multiple auxiliary requests. And it's basically by combining independent claim with one or more dependent claims, or then you can actually limit the claim in some other way. For instance, move text or language from the specification into the claim, although there you always have to watch out that there's not an added matter issue because you need support in the application as originally filed. From a procedural litigation point of view, you can either do that in your brief as part of your prayers for relief, or then as a so-called verbal limitation in your brief, or you can also go to the Patent Office, or in the case of European patent, even to the European Patent Office, and request a central limitation. Thank you.
Thank you. And next question is to Lawyer Fang. And about the grounds for stay of proceeding in a court which is trying a patent infringement case, what do you mean by the requirement that description is inapplicable for interpretation of the claims? Also, if there is a ground to invalidate the patent other than this, would the court stay the proceeding?
Oh, thank you for the question. The answer is, if there is any inconsistency or contradiction between the claims and the description of the patent, obviously violating the provision of Article 26, paragraph 3 and 4, sufficiency of disclosure element requirement and the supporting requirement of the Chinese patent law, and thus resulting in an inability to use the description to interpret the claims, and a party has initiated the patent invalidation procedure accordingly and applied for the suspension of the patent lawsuit, the court may rule the suspension of the lawsuit. But if the party concerned definitely rejects resolving the dispute through the patent invalidation procedure, or forced to file a request for patent invalidation within a reasonable time, the patent shall be deemed valid and the protection scope of the patent shall be determined based on the literal meaning of the claims. And if the patent still has substantive defects, such as lack of inventiveness or novelty, that may result in invalidation, the court may inform the parties to resolve the dispute through the patent invalidation procedure. As I said before, if the party concerned definitely rejects resolving the dispute through the invalidation procedure or forced to file patent invalidation in a reasonable time, the patent shall be deemed valid and the court may continue the proceeding. Thank you.
Thank you. And let's go to the next PowerPoint. This PowerPoint is about this question. Is prosecution history considered as a basis for claim construction? The answers are divided. I will ask to Judge ALSUP first. Regarding the claim disclaimer principle, how are the factors to apply the principle different from the factors in invoking prosecution history estoppel? Is there any particularly distinguished effect other than the basically same effects?
In my view, the literal infringement and equivalent infringement inquiries are very similar under U.S. law, even though they go by different names. For literal infringement, it's claim disclaimer, that's what it's called, and for equivalence, infringement by equivalence, it's prosecution history estoppel, keeping in mind that there's an equitable history, so estoppel is equitable, equivalent is equitable, so they go by two different names, but the analysis is very similar for both. I'll give you one example. It most often let me start by saying, in the U.S., prosecution history is almost as important as the specification. You must read that prosecution. I always want to see the prosecution history on every claim that I'm about to construe. I want to see what they told the patent office when they tried to get the patent. The most frequent time that this problem comes up is during prosecution history. The examiner may cite to some prior art and say claim number 1 is invalid on account of the prior art. And then the applicant comes back and says, oh no, our claim doesn't cover that. Our claim is different because we are claiming, in addition to all of that, we're claiming X, some additional implicit limitation. So then, unfortunately, the examiner shrugs his or her shoulders and signs off on the patent. So then it comes to court. And then the patentee, now patentee, not applicant anymore, wants to forget what they told the patent office. But no, we will remember what they told the patent office, and you cannot get away with having it both ways. That's an American phrase. You can't have it both ways. So if you told the patent office it doesn't cover X, the claim does not cover that point, then you cannot sue for that under any doctrine in the USA. This comes up a lot. But essentially the analysis is the same whether you're using literal infringement or by doctrine of equivalence.
Thank you. And next question is for Judge SCHÖN. While prosecution history is generally not considered in Germany, whether the issue is literal infringement or infringement by equivalence, it is also stated that if it is obvious that parts of the description or drawings do not fall into the claims, they should not be considered under the doctrine of equivalence because the patent owner decided not to include them in the claims. Then, when is it obvious that parts of the description or drawings do not fall into claims? And could you tell me the difference between not considering under the doctrine of equivalence because the patent owner decided not to include them in the claims and the doctrine of prosecution history estoppel?
Thank you very much. So your question refers to a decision of the Federal Supreme Court from 2011 called Okklusionsvorrichtung, occlusion device. It was a case where in the patent application there were two examples described, and during the application process the patent holder decided to skip one of these examples, so the claims did only show one example, but during the application process, they did not correct the description. So you had a claim describing just one device, but the description showing like the original version. So, and there was an infringement case, and the patent holder asked for like infringement of the original second device, which was skipped during the application process. And so the first instance, second instance court said there's infringement by doctrine of equivalence, but the Federal Supreme Court said in this case, this would be unfair because the patent holder made a choice, so he decided not to ask for the second version. And so it's, I think it's not a conflict with that we do not look into the prosecution history, because in this case, it was obvious by looking at the claims and the description that there have been a change. And the problem with this decision was basically that the decision of the Supreme Court was adopted in a way by the lower courts, that the lower courts were very strict by using the doctrine of equivalence. So the lower courts thought that every time that something is mentioned in the description but not in the claims, it cannot be used by the doctrine of equivalence. But in later decisions, the Supreme Court explained in detail that only in exceptional cases this kind of exception can be made. Thank you.
Thank you. And as this is the end of second topic, let's move on to the third topic. The third topic is means plus function claims. The PowerPoint is about this question. Does your country allow applicants to write claims with means plus function claims? And do Patent Act and other laws in your country contain specific provisions regarding means plus function claims? As you see, there is a specific provision only in US. And here's a question to Dr. CALAME. Under Swiss law and the EPO guidelines, when do you allow means plus function claims?
Yeah, thank you. Yeah. As opposed to the United States, we don't really have the specific term means plus function claim. It is, however, well recognized in the European Patent Convention that patent claims can be drafted using both structural and functional claim features. And so you specifically asked about the EPO guidelines for examination. They basically say that the functional features may be included in the claims if, and I quote, the skilled person would appreciate that other means could be used for the same function. So if the description is phrased in a way that skilled person will not think that other means could be used to perform that function, then an objection will arise in the prosecution of the patents. However, there is one instance where the EPO examination guidelines use the term means plus function claim, and that is in the context of computer implemented inventions. So if you take as an example, you have, for instance, as a claim 1, you have a method claim. It's a computer implemented method comprising steps A, B, C, whatever, a couple of steps. And then as a claim 2, you would have an apparatus claim. So that would be, for instance, a data processing apparatus comprising means for carrying out steps of method claim 1. So that would be considered a means plus function apparatus claim. And those claims, and basically what the examination guidelines state is that these claims, such means plus function claims, are allowable in the specific field of computer implemented inventions. And there is one specific, very important clarification in the guidelines is that this means for carrying out has to be interpreted as means adapted to carry out the relevant steps. And for those of you who are familiar with the European Patent Convention, it's because typically under the European Patent Convention, if you have the term for, that is usually interpreted as suitable for. And so this is very important because This is important with regard to anticipation, with regard to novelty. If a known process is suitable for carrying out a process or some relevant steps, but not adapted to carry out the relevant steps, the known apparatus will then not deprive the claim of novelty because of that clarification in the guidelines. Otherwise, under European patent law, such a known apparatus would otherwise then deprive the claim of novelty. Thank you.
Thank you. And next question is to Lawyer Fang. When do you allow means plus function claims under Chinese Patent Office guideline?
Yes, thank you. According to the provisions of the guidelines for patent examination, usually for product claims, functional tech features shall be avoided as far as possible to be used for defining the invention. It is only when a certain technical feature cannot be defined by a structural feature, or it is more appropriate to be defined by a function feature, then a structure feature and the set function can be directly and definitely verified by experiments and operations as stated in the description or common means in the art, that the definition by function features in a product can be permissible. So it's clear that in the current laws and the regulations of China do not encourage the defining of claims by reference to function features. Thank you.
Thank you. And the next PowerPoint is about this question. Do courts in your country take a different approach when constructing means plus function claims than when constructing typical claims? The answers are divided. I have a question to Judge ALSUP. If a claim is written in functional languages, they can incorporate a broad scope of elements, but the description in the specification only provides a single embodiment. Do you expect an extreme case here? That is, the scope of protection is interpreted as being limited to the single embodiment?
Yes. The law is very clear in the U.S. when you use means plus function, that is defined by the structure set forth in the specification for carrying out that function, plus its equivalence. So that structure plus its equivalence, but nothing more, nothing beyond that, even though the language of the claim is quite broad, the claim will be limited to the structure disclosed in the specification plus its equivalence. So the answer is very narrow.
Okay. Thank you. And next question is to Lawyer Fang again. And please explain whether means plus function claims are interpreted in the same way as other claims, or whether there is a special construction method for these claims. Also, please explain whether means plus function claims are interpreted all the same when determining patentability as when determining infringement.
Thank you. At present, in the practice of China, there are some differences in the interpretation of means plus function claims in different procedures. First, in the patent grant procedures, the function features are interpreted as including all means that can realize the function. This kind of interpretations is within the scope of the maximum reasonable interpretations. However, in infringement proceedings, the interpretations of function features are interpreted as technical features that are identical or equivalent to those that can realize the function described in the descriptions, rather than all the technical features that can realize the function recognized in patent grant procedures. But in the invalidation procedure, the interpretations of function claims are controversial. One opinion is that patent invalidation procedures are the extension and the supplement to patent grant procedures. are also to determine patentability. That is, the function of features should be interpreted, including all technical means that can realize the function. The other opinion is that the patentee are not as free to amend the patent claims as they are in patent grant procedures. If the same method of interpretation is used in both procedures, patents will be invalid easily. So interpretations in the invalidation procedures should be the same as those in patent infringement procedures. That is, the function features are interpreted as technical features that are identical or equivalent to that can realize the function described in the description. Thank you.
Thank you. And let's go to next PowerPoint. The question was, are means plus function claims constructed differently when deciding on patentability and patent infringement? In most countries, they are not constructed differently when deciding on patentability and patent infringement, except in China. I have a question to Judge Park. Could you explain Korean court's position on interpretation of means plus function claims?
Honorable moderator and panelists, it's a great honor to have a session with you. And I'm very grateful to the audience for opportunity to speak as well. In this session, I will talk about the case and legal principle of Court of Korea. The Korean legal system does not have restrictive provisions that recognize means plus function claims when meeting certain requirements and does not give special treatment to such claims. Therefore, it is difficult to take a special approach for construction just because a claim is a means plus function claim. And most of Supreme Court decisions use expressions such as patent claim that includes the definition of a product by its function, effect, and property, etc. Instead of referring to these claims in separate terms that is distinct from the typical claims. In particular, the Supreme Court decision in 2009 clearly ruled that general principles should be equally applied to these claims. I prepared some presentation materials. In this case, Composition 1 of Claim 15 stated means of determination for determining proportion of the character by the player's manipulation. Meanwhile, according to the description of the invention, a character's proportion is explained as a character's height and weight. In addition, means of determination is explained as a composition where a player arbitrarily expands or contracts a character by cross-key manipulation in the vertical and horizontal direction and determines height and weight. Or a composition where a player selects a default character's proportion at the character selection screen. The court viewed that it is a patent claim that includes the definition of a product by its function and property. And the court ruled that it is constructed in principle as all compositions performing actions or functions of determining character's proportion by player's manipulation. However, accurate understanding of the technical meaning of the claim requires reference to the description of the invention, as the general principles state. Thus, the court concluded that the composition 1 is constructed as meaning the composition to determine the character's proportion by player's manipulation, like in the description. Many terms used for means plus function claims are unspecific. As a result, for means plus function claims, it is impracticable to specifically determine the technical feature of the invention solely based on the claims. Consequently, it is essential to practically determine the content of the invention by referring to the description of the invention in the specification. Since general principles equally applied to means plus function claims, the claims are not constructed differently when deciding on patentability and patent infringement. I finished my remarks. Thank you.
Thank you. And the next question is to Judge TSURUOKA. This question relates to two Japanese cases on means plus function claims. The ball bearing automatic selection and assembly device case in 1978 and the magnetic media reader case in 1998. Could you explain the holdings of these two cases and their implications? Also, the two cases are infringement cases, but do you think the standards equally apply to means plus function claim construction in patentability cases?
Thank you very much for question. The 1978 case was a case where the wording of the claim that measurement means and assembly means cooperate became a problem. The judgment held as follows. This wording is extremely functional and abstract, and its specific composition is not clear by itself. Therefore, the meaning of that claim should be determined by knowing the specific technical ideas disclosed in the embodiments described in the specification. The 1998 case was a case where the wording of the claim of rotation restricting means of the magnetic head became a problem. The judgment held as follows. The claim in question expresses the structure of the invention with abstract actions and effects, and the content of the invention is not clear by itself. Therefore, the technical scope should be determined based on the technical idea indicated by the specific configuration described in the specification. Both of these two judgments require reference to the description of the embodiment. But this does not mean that the technical scope of the claim is limited to the embodiments. It can include configurations that can be easily implemented by those skilled in the art based on the statement of the specification. On the other hand, the scope of claim cannot include technical ideas that cannot be easily implemented by those skilled in the art. This judgment represents general thinking in Japan, and I think this concept can be applied to the claim construction in the inventive step judgment too. Thank you very much.
Thank you. As you know, all of these topics are not easy to understand in one session, and finally we have reached the final topic. The last topic is product by process claims, and the PowerPoint is about this question. In your country, are product by process claims understood as product claims or process claims, or a different type of claims that do not fall under either of them? As you can see, in most countries, product by process claims are understood as product claims in patentability step, but it seems that in some countries they are not just product claims in infringement step. Therefore, this question leads to next question. Next PowerPoint is about this question. Are product by process claims interpreted differently when judging patentability and patent infringement? And this question is to Judge ALSUP. In the US, how are product by process claims interpreted when judging patentability compared to when judging patent infringement?
In the U.S., for validity purposes, meaning patentability purposes, you only look at the product. You don't look at the process. And the reason for that is that if the product is already out there in the market, for example, then it's already been invented. On the other hand, in that case, it would be invalid or not patentable. But let's say you do get the patent, then you sue someone for infringement, then you must prove not only that they come up with the same product, but it's also manufactured through the same process that is described in the patent, in the claim of the patent. So there is a difference. This is one of the few times in U.S. patent law where a different standard is used for infringement versus used for patentability. I will end by saying in 20 years as a judge, and I've gone through many hundreds of these patent cases, I have never seen a claim like this. These are rare in my experience in the USA, this form of claiming an invention.
Thank you. And next question is to Lawyer Fang. Would you introduce major decisions or interpretations by the Supreme People's Court on claim construction of product by process claims?
Thank you. It's a last question for me, so I will slow down my speed. In China, according to the provisions of the guidelines for patent examination, product by process claim are similar to or identical to product claims defined by the features of process. The subject matter of the product claim defined by the features of process is still the product claims. If the features of process have an actual defective effect on the product itself, then all technical features, including the features of process, should be considered in determining the novelty and inventiveness of the product claims. So, in the patentability procedure, there are two cases. One is that the feature of process do not have an actual definitive effect on the product itself, then interpreted as product. The other is that features of process have an actual definitive effect on the product itself, then interpreted as process and product. According to the article of the interpretation of the Supreme People's Court, it provides that while the patent claim defines technical features by the method of production and the preparation, if the method of production and the preparation of the alleged infringing product is neither identical nor equivalent, the People's Court shall rule that alleged infringing technical scheme does not fall under the scope of protection of the patent. So, according to the interpretations, in the patent infringement procedure, the interpretation for the product claims defined by the features of the products adopts the full definition method. That is, all the technical features defined in the claims are not negligible. Since the features of process are defined, they should be considered to constitute a defining feature of the product. Thank you.
Thank you. And next question is to Dr. CALAME. And please explain whether Swiss law adopts a different claim interpretation method for product by process claims than other ordinary product claims.
Yes, thank you for the question. No, the court will apply the same approach to claim interpretation. So the situation in Switzerland is the opposite of what it is in the United States. So the scope of protection of product by process claims is what we call absolute. So that means that the process features are not considered limiting in product by process claims. So it means that they are infringed regardless of how the product is produced. I note that this is the case in Switzerland, but I'm aware of the fact that not all the member states of the European Patent Convention have that same law. Thank you.
Thank you. And next question is to Judge Park. Please introduce the Supreme Court's en banc decision on construction of a product by process claim, the 2011 WHO 927 decision on January 22nd, 2015. What did the court say and what are the implications?
Yeah, let me start. The Patent Act of Korea categorizes inventions into a product invention, a process invention, and an invention of product manufacturing process. In the case of product by process claims, that is PBP, even if a manufacturing process is described, the object of an invention is not the manufacturing process, but the product itself to be finally obtained. And therefore, PBP claims are product claims. The Supreme Court's en banc decision in 2015 made a clear ruling on this point. The en banc decision ruled that the technical composition of PBP should be identified as a product, having the structure or properties identified in the description of claims. Please show us the presentation material. Yeah. Existing polyvinyl alcohol, that is PVA-based films, have a problem that part of PVA dissolves during the manufacturing process so that defects occur on the films. The patented invention of the case solved this problem by washing PVA raw material with water prior to the manufacturing process, thereby preventing the occurrence of defects on the film caused by eluted PVA, and thereby allowing to obtain a film with few defects at a high yield. Claims 6 and 7 are related to manufacturing process. The inventive step of these claims were not denied because such a technical idea was neither disclosed at all nor implied in prior arts. Meanwhile, Claim 9 and 10 are related to PBP. The technical characteristic of increasing the yield of the film with few defects is not a feature influencing the structure or property of the film itself, which is the final product. Thus, the inventive step of these claims was denied under the legal principle of the en banc decision. The noteworthy matters of the en banc decision can be summarized as follows. First, PBP was constructed faithfully based on the format of a product invention. Second, the court did not distinguish the construction principles for PBP depending on whether there are any special circumstances where a product can be defined only by its manufacturing process. Moreover, given that it was a decision on the case with no special circumstances, it can be deemed to imply the court's position of accepting the previous practice that broadly utilize the PBP irrespective of the existence of such a special circumstance. In addition, the en banc decision defined the PBP as an invention which overall claims as a whole are described as a product and include the description of the manufacturing process. Since the decision, the courts of Korea have used the expression a product invention, including the manufacturing process for PBP. This concludes my remarks. Thank you very much.
Thank you. And the last PowerPoint of the last topic. Yeah. The question is, are patent applicants allowed to write a claim as a product by process claim only if there exist special circumstances where the product can be identified solely by the manufacturing process, or are patent applicants allowed to write claims as a product by process claim regardless of the existence of those special circumstances. Here's a question to Dr. CALAME. Please share with us the requirements under the Swiss law and the EPC guidelines that allow a claim to be drafted as a product by process claim.
Yes, thank you. Yeah, as a matter of European patent law, product by process claims are admissible only if they products themselves fulfill the requirements for patentability, and now this is important, if the products cannot be described in any other way. So that means basically that there is no other information available, such as the composition, structure, or other testable parameter, where you can reference that and basically define the product as such. So there's really the only way to define the claimed product is in terms of the process of manufacture. Only in these cases is it allowable to draft such a product by process claim. But I concur with Judge ALSUP. Actually, these are they're very rare, but they exist. Thank you.
Thank you. And the last question is to Judge TSURUOKA. Could you introduce major decisions on product by process claims in Japan, such as the IP High Court's 2012 en banc decision and the Supreme Court's 2015 decision? What are these cases about and what do they mean? Please also describe how the Supreme Court decision affected patent application and examination practices in Japan.
The IP High Court decision and the Supreme Court decision are different. To the disappointment of IP Court judges, the Supreme Court reversed the IP High Court decision. First, IP High Court decision. This decision is hold as follows. Product by process claims, PBP claims, can be divided into two cases when it is impossible or difficult to identify an object by its structure or characteristic, and when it is not. In either case, the patent is valid, and the scope of rights is different. In the former case, the scope of rights includes those having the same structure, characteristics, etc., as those made by the manufacturing method described in the claims. In the latter case, the scope of rights is limited to those made by the manufacturing method described in the claims. The Supreme Court decision also divided PBP claims into two cases when it is impossible or impractical to identify an object by its structure or characteristics, and when it is not. In the former case, the patent is valid, and the scope of its rights covers the objects having the same structure, characteristics, etc., as those made by the manufacturing method described in the claim. However, in the latter case, the patent lacks clarity requirements and invalid. This Supreme Court decision invalidates PBP claims that do not meet the requirements. As a result, both the patent applicant and the JPO, Japan Patent Office, have to carefully judge where the patent for the application falls under a PBP claim or not. For this reason, the JPO has created a guideline for determining whether it is a PBP claim or not and published it. However, the IP High Court decision after the Supreme Court decision tends to limit cases that fall under PBP claims. For example, there are some court cases that hold that claims in question do not fall under PBP claims because they only describe the state of an object rather than the process. These decisions have led to the general understanding that the impact of the Supreme Court decision may be less than originally thought. Thank you very much.
Thank you. And as you know, we have some minutes left. And can you see? As you can see from the reference book, Attorney CALAME briefly introduced the patent litigation system in Switzerland. Some of you may be interested in the Swiss patent litigation system. So I'd like to take this opportunity to ask Attorney CALAME to introduce the patent litigation system in Switzerland. Please.
Thank you very much. That's very rare for Switzerland to become such a prominent role. But we have actually just very recently, we have reformed the patent system. Just 7 years ago, a single federal patent court was introduced in Switzerland to hear all patent cases relating to validity and infringement. It used to be in the competence of the cantonal courts. There were 26 different judges were competent for hearing patent cases, which, given the small size of Switzerland, was not a very good system. It meant that some of the judges had maybe a patent case every 2 years. Now we have a federal patent court with both legal and technical judges, and the technical judges are trained European patent attorneys, and it's always kind of an interesting system to explain, especially to US clients, because given the small size of the country and the number of cases, we have about maybe 40 patent cases a year, all of these technical judges are actually part-time patent attorneys. And so that leads to a situation, and also in addition to that, there's even in-house counsel that actually have a role as a technical judge, and that leads to a situation where you could have maybe a technical judge from Roche sitting on your pharmaceutical case, which sometimes is difficult to explain. But I think it has turned out to be a very good system. The technical expertise on the bench has proven to be very helpful. Thank you very much.
Thank you. And we still have some more minutes left, but I think we dealt with such a difficult topics here, so I think it's better to rest earlier than expected time. And thank you for our speakers. Although views and practices differ from country to country, I believe that is an opportunity to understand each other by exchanging and discussing different views and opinions. I'd like to thank our audience for listening and joining us. I hope you enjoy other sessions later this afternoon. Thank you.
Thank you, everyone. It was an amazing session, and amazingly difficult session too. This ends session 1. Session 2 starts at 2:30 p.m. after lunch break. Lunch is served at the food table outside this room. Please enjoy lunch. Thank you.
Very distinctive, that's right.